I am in the premises of Magistrate Court 2, Oka, Anambra State. I am here with my clients. You can see us. We are still in court. The Honorable Magistrate granted my client bail in a very simple offense. And my client met the conditions of the bail. But the clerks of court that I must give her 20,000 naira before she will take the records, the surety bond to the magistrate to sign. The clerk of the court also insulted me and called me names. This is the person that went to the magistrate for him to sign the document and return back and said that the magistrate said that we must bring 20,000 naira, whether we like it or not. If there is no justice for the common man in the judiciary, there will not be justice anywhere. When somebody is granted...
Well, that should be the essence of the judiciary, really. Justice for the common man. That video since gone viral online. And this morning, as much as we talk about the new dispensation, what will be, the president is meant to swear in a new CJN, Justice Kudirat Kekereekun, later today. But these are some of the issues that she'll have to confront at various levels. She is one of several people who will be playing in the judiciary. So this morning, we're digging deeper into the vital issues that affect the delivery of justice for the common man and, by extension, the generality of Nigerians. We have joining us on the show that man you saw there. His name, Emenike Chioke, is a human rights lawyer, as you can tell, and partner at Top Law and Attorneys. Enugu joins us virtually on the program. You're welcome to the Morning Brief, Emenike Chioke.
Thank you very much.
Well, lots of questions, really, and we're tying this conversation to the big picture. You know, it's like pixels, picture elements that make up the big picture. If we're not able to sort these things, then when we look at the big picture of the judiciary, what we see might not be palatable. So let's start off with that video, and we'll talk about, you know, proper independence from the judiciary, independence from political influence, from corruption in this case. But I'd like you to speak to that video because a lot of people saw it and they're seeking some sort of closure. Has there been a closure to that 20,000 naira being demanded? You said that you were going to come back. Have you come back? Has that been resolved? We'd like you to speak to us on that first, then we'll dovetail into other issues.
Okay, the last time I spoke with the Chief Registrar of Anambra State Judiciary, she assured me that the matter is being seriously investigated. I have not heard of any outcome of the investigation, but I believe that the stakeholders and the persons who are interested in the independence and in the fair running of the judiciary are on top of the matter. I believe they are definitely on top of the matter. We have not yet been contacted, but I believe that when they are done their investigation, that we will become contacted.
Right, and this is something we've heard across board in other parts of the country as well. So it's not just limited to the Magistrate Court 2 where you experience that. We've heard these reports in other parts of the country, and these are the issues that add up to give the judiciary sometimes a bad name, a bad image. So let's get to work. New CJN to be sworn in today by the president. A lot of people have spoken about her stellar performance, how she's incorruptible, and how her coming on board would mean great things for the judiciary. And I'd like us to identify these issues that you would expect her, and of course, other stakeholders in the judiciary to take on. If you had a priority list, what will that priority list look like?
You know, the first thing is that we need to get it right. The judiciary needs to get it right. The bedrock of justice and fairness in the judiciary is independence of the judiciary. In Nigeria, the mode of appointment of judicial officers is ridden with flaws. If you go to the chapter 7 of the Constitution, that chapter states the governor shall appoint the chief judge of a state. The president shall appoint the chief justice of the federation. It cannot work in a democratic society where the president and the governor are elected, the heads of the legislative are elected, but when it comes to the judiciary becomes a stooge of the executive. That is in essence an extension of the arm of the executive. So the judiciary cannot be independent. The judiciary cannot obviously be independent when the chief judge and when the chief justice is appointed by the president or governor respectively. It cannot work in a judiciary in a democratic society. So the first thing we need to get right is a constitutional amendment. When there is a constitutional amendment, removing the power of appointment of judicial officers from the executive, maybe that is where we can start from. We, the bar members, we are closer to the bench. The lawyers who are practicing, who are ministers in the temple of justice, know the members of the judiciary that are corrupt and the ones that are upright. So if the appointment will cease and it will now be by election by the people that understand the functionality of the judiciary, maybe with a constitutional amendment to that effect, we can start getting it right.
All right, Mr. Achiuoke.
Now tell me.
Mr. Achiuoke, let's dig deep. There's section 231 of the Constitution where the Chief Judge or Chief Justice of Nigeria is appointed. 3 people are involved. The language is the President will appoint based on the recommendation of the National Judicial Council, and then the Senate will confirm. Is there a problem with the framing of that? Do you also see that as unilateral decision of the executive arm, given that the recommendation has to come from the NJC and then confirmation by the Senate?
The truth is that the judiciary must be an independent arm of government. Let the executive not have an arm. Look, the word there is appoint. It simply means that the executive or the governor or the president can refuse to exercise the power of appointment, even in the presence of the recommendation of the NJC. So if the NJC recommends and the executive refuses to appoint, I mean, what does that tell us? And now, let us calm down. The NJC can do its job of recommending, and then let the people that understand the workings of the justice system do the voting and not even appointment. Let there be a constitutional amendment, making it a vote, making it an election. Because when you say appointment, the appointment can be influenced one way or the other. Even though we have a blanket provision of the NJC recommending, the executive, the governor or the president can still grossly affect who is appointed and who is dismissed. Remember, when a justice of the Supreme Court was dismissed by the president of Nigeria, I mean, we know when the former CJN of Nigeria was dismissed by the former president of the Federation. Judiciary must be not just on paper, not just on theory, but in practice, totally independent. The practitioners in the temple of justice can determine, can know who are the upright, courageous, and incorruptible members of the judiciary.
Mr. Chair,
if the apex position in the judiciary is elected, they will be more accountable to dispensation of justice and not to the present administration. Yes, I have a personal problem with the fact that the chief executive of the federation or the state has to do the appointment. he was elected.
All right.
When it comes to a crucial fiber of a society which is justice administration, it is subjected to appointment and then confirmation by the Senate. Do I need to tell you that most of the members of the legislative arm do not represent us? They do not, in reality, they do not represent the interests of the masses. We know that they still represent largely their personal and political interests.
All right, Mr.
So
Chukwuka.
if the appointments.
Yes, we've talked about this reform and constitutional reforms a lot right now, but let's turn our attention to the delay in court cases and, of course, hearing. If we listen to the outgoing CJN yesterday, he talked about how cases that are supposed to be, not even supposed to reach the apex court, should actually be terminated at the appellate court, eventually get to the apex court. And talking about this, you now decide, is it corruption taking it there? What is going on? Are some people more special in this case? Why does it have to get to the Supreme Court? Talk to us about how this can actually be reduced so that cases, serious cases, actually get to the Supreme Court when there is need to, and not just on serious cases, allow me to use that, getting there.
Yes, when justice is clearly seen to be done, when justice is clear, why won't a party accept the decision of that court? The first reason why a litigant will decide to go higher to the apex or to the appellate and then to the apex court is because justice is not seen clearly to be done. So by the time he appeals, he's still seeking for that justice that he feels he was denied at the lower or at the trial court. So it is still a question, is the judiciary courageous and independent enough to dispense fairness without any partiality, without any favoritism? For example, if I have a personal case with the governor of my state or the executive arm of government, how am I sure that the judiciary in that state will give me justice when the judiciary is obviously or loyal to the executive? So we are still talking about the same thing. If the judiciary is totally, starting from the way it is appointed, independent, and if they are well remunerated in such a way that bribery or will not be an issue to both the staff of the judiciary and the members of the judiciary, it will help in curbing issues of excessive appeal. I mean, that is my take on that.
Right.
When justice is fair, when administration of justice is open and is fair, and we uphold the tenets, the tenets of justice, a party will be more comfortable accepting the dictates or the rulings of courts.
Right. Let me quickly come in now, because just recently the president approved a 300% salary increment for judicial officers. Whether or not that would change much as far as what you refer to as, recorded corruption in the judiciary is yet to be seen. Obviously, there's a lot of work to be done in terms of amendment, true independence, and that has been talked about. Even the former CJN now was talking about the judiciary being overburdened. But I want us to move a bit, because again, there's a big picture. There is what happens in the court, and there's what happens before you get into the court, and even after you're done in the court. And I go back to that video which you did, because these things actually add up to affect justice delivery. So I'd like you to also speak to some of the recommendations you may have for court clerks, some of those, adjoining issues that affect, imagine a client being granted bail and they say bail is free and you have to go through that. Obviously, justice has not been delivered, right? So recommendations for all those other issues that happen outside the courts and don't necessarily happen in the courts that you think that, well, should be brought up.
Yes. See, I tell you this, when a judicial officer is seen to be upright, at least in the dispensation of justice, the other staffs behind the scene will fall in line. It is not a rocket science that when a judge of a court is incorruptible, you cannot tell me that the clerk of court will have the boldness to delve into corruption. Even if they want to do it, it will not be with brazen audacity. So it trickles down from the head from the top, it goes down to the last of the personnel. So if the members of the judiciary, the judges, the magistrates, if they get it right, if they are seen to be incorruptible, then behind the scene, the other staff of the judiciary will fall in line. Now, like in Enugu State High Court, for example, in Enugu State High Court, there are cameras everywhere monitoring the activities of the staff of the judiciary. Yes, they are monitored because there have been complaints about this issue of extortion of lawyers, and the Enugu State Judiciary came up with a system to monitor the activities of the courts of clerk. Now, it curbed it to a very large extent. So, but what I'm saying, the paramount interest is the judicial officers themselves. When the judicial officers uphold their oath of dispensation of justice without fear of favor, the other staff will fall in line.
All right, Mr. Chi, okay, let's remember that the judiciary is made up of the bar and the bench. So let's talk about the bar which you belong to. We've seen the lawyers also behave in a way that is not quite impressive. I'll give you a quick example. So for instance, a lawyer who went to the university, went to law school, graduated, should know some basic housekeeping rules and basics of the law. Things as simple as what court has jurisdiction over what issue is as basic can be. So sometimes it feels like tempting their law judges or law justices or the judges in court. When you go to a court, because that's one of the first things that will be established, whether that case can be heard in that particular court. So whilst we're shouting about sanitizing the bench, what do you have to say about the bar itself that has its own issue when someone approaches a court that doesn't have jurisdiction? And somehow the judge, some are bold enough to say, this is wanting in jurisdiction, so I can't adjudicate over this. So it dismisses the case or strikes it out or whatever. But for some, for whatever reason, they'll speak to the ancillary issue and forget about the substantive issue. What's your take?
Well, ancillary issues are not the bane of justice. You know, justice is more substantive than procedural. That is why in the courts these days, when issues of procedure, when issues of technicalities come up, we implore the courts to focus more on the issue of substance and not the issue of technicality. But the issue of jurisdiction, a litigant or going to the wrong court, those ones are determined at the preliminary stage. I mean, if a party or if a counsel allows a case to go on in a wrong court, he is deemed to have waived his rights. He is stopped from raising that issue of procedural defects, except it goes to the root of the matter, except it affects the substance of the case itself, thereby affecting substantive justice. For example, commencing a case in a wrong judicial division is not a ground is not a ground for denying justice to the person that commenced the case in the wrong judicial division. So justice is more substantive than procedural, but it behoves the lawyer to do his homework, to do due diligence
I asked a straight question.
A matter in the right court.
If you ask me, I asked a straight question. So when we talked about the bench, you were saying, let it be by election. Let it not be by appointment of the president. Now I've brought it to the bar, which you belong to. How do we reprimand effectively erring lawyers who know what to do and do the wrong things? That's what I mean.
We have LPDC, Legal Professional Disciplinary Committee. Yes, we have such body that disciplines lawyers too. If a litigant feels that a lawyer was grossly negligent in not knowing the basic tenets of the law, the basic issues of jurisdiction, I mean, an aggrieved party, a litigant can still take up the lawyer's incompetence in LPDC. He can still petition the Legal Professional Disciplinary Committee for the lawyer to be either sanctioned, disciplined, or even made to refund any fees he may have collected from such clients. So I mean, we have structure for disciplining of members of the bar, and I encourage members of the public to explore that structure too.
Mr. Chioke, just before we let you go, I mean, a lot of people, some have argued about the court not having armed security or enforcement agencies when they get results, and they rely heavily on the police or other security agencies, especially when it comes to matters that concern government and generally cases where the government has interest in. Is this a situation about talking, of course, when we're talking about the independence of the judiciary, is this a conversation that we can begin to have as players in this sector?
Yes, definitely. In fact, you'll be so frustrated when you get justice against the executive arm of government. Who will execute it? The police? The military? Assuming you get a court order against DSS or against Nigerian Army or Nigerian Air Force or against any of the military or paramilitary organizations, who is going to help you enforce that court order? In fact, there's even a provision that for you to enforce any court order, any judgment against the government, you have to obtain the permission in writing of the Attorney General of the Federation or the state, as the case may be. The Attorney General that was appointed by the executive will still give you permission to enforce a court order against the executive. I mean, if the judiciary must be independent, there must be a forceful backing to its decisions. In this country, it is only against poor tenants that the bailiffs of court have power to enforce judgments of the court. Only against. How have we enforced judgments of the court against DSS in this country, against Nigerian police? How have we been able to enforce court orders against them? How have we been able to attach properties of some agencies of the government that we obtain judgments against? How can we? I mean, it's so frustrating that after spending some years in court and getting justice, now enforcing it, for you to enforce justice, you have to begin another legal proceedings called Judicial proceedings to either attach money in bank or attach property.
Right. Emenike Chioke, quite a number of issues you have raised, really, and clearly there's a job of work to be done by the new CJN, as well as the bar, because clearly this is a work that has to be done together. But we'd like to thank you so much. The passion with which you approach issues about the judiciary clearly shows that you want things to get better. Human rights lawyer, partner, Top Law, and attorney Zenugu Emenike Chioke, thank you so much for your time on the show this morning.
Thank you, sir. Thank you, sir. It's a pleasure.
Yes, a lot to chew on. But we'll take a moment now. When we return, we'll turn our attention to the tourist sites in Nigeria. Guess who joins us? the Minister of Tourism. You don't want to miss this. Stay with us.